If you and your spouse are facing divorce and you've accumulated a lot of things, a lot of expensive things, maybe you've got the big house on the water, maybe you've got a mountain house, maybe you've got the boat and an art collection and a wine collection and who knows what. You're looking at divorce and now you're thinking, what do we do with all this? And isn't this way more complicated? How can we make this simpler? The fact of the matter is it is a little complicated. If you had nothing, you could just sign some papers and get out, right? Potentially. If you've got all of these things that you accumulated together, now you've got to figure out how to divide them together. You're going to figure out how to divide it up. Unfortunately, in that situation, for very fortunate people, we need to have some experts come in who specialize in valuing the very things that have made your life very rich and full, so that you can either let those things go and continue to have a rich and full life, or decide which of those things continues to enrich your life in the new chapter. Let's say you have accumulated a lot of wonderful things during the course of your marriage that make your life aesthetically wonderful. For example, a fantastic art collection with some really great pieces by very well-known dead artists or live artists for that matter. And now you want to know, well, who gets what, or are we selling it and what's it worth? And how do we account for that fabulous art collection on the equitable distribution schedule? The fact of the matter is that unless you are an art dealer yourself, you probably don't have a specific beat on how much that art collection is worth. So this is where we would, as a law firm, we would reach out to an expert to decide who is an art dealer or an art valuator, or sometimes an estate assessor can have that background. So we would look for the appropriate type of expert to come in and look at that type of art from that period, so that they specialize in that and they can give us a value on that. You can either each get your own valuator for that purpose, or you can agree on a neutral and go with that number. So it's a little bit complicated. It's doable. In the course of a divorce, when one of the spouses is an extremely high earner and the other spouse has not earned as much, has been more of the person that was on the home front or taking care of the kids, or has worked part-time to allow for, supporting the lifestyle of the higher earner. In that case, there's often a question, and we can get really upset about the idea of child support and having to go get another job just to pay for the child support. I already make enough. Now I'm going to have to go make more. The fact of the matter is that child support under Florida law is a statutory math problem. It's the same statutory math problem for everyone, regardless of how much money you make. The amount that comes out on the bottom line may differ because of that, but it is capped. There is, based on the incomes of the parties and some other deductions that come into play. What we do is we use some really fancy software that plugs in the numbers and spits out the result, and it's a math problem. If you are facing a divorce and you have accumulated a lot of wealth over the course of your lifetime with your spouse, and you're the one that primarily earned it, you may be worrying right now, or you may be even angry, because it's a pretty emotional topic, that your spouse is going to get alimony and rake you over the coals and steal all your money. That may be what you're thinking. And we get it. It's one of the most emotional topics that people face. One of the most emotionally triggering issues during the course of a divorce is the idea of alimony or spousal support. The fact of the matter is that, unlike child support, in the spousal support arena, what determines whether or not there's going to be any spousal support at all is need. Does your soon-to-be ex-spouse need the money? Ability to pay. Do you have the ability to pay? And then also, we're looking at the lifestyle that the parties came to create together during the course of the marriage. So certainly there may be a need for, or your spouse may be eligible for more in alimony or spousal support than someone who made nothing over the course of their lifetime and lived very simply. That said, spousal support is not uncapped. It is the cap is actually the 35% of the difference in your net incomes. So the greater that divide is, the greater that 35% may be, but it is indeed capped. If you happen to be on the brink of divorce and you're wondering whether or not your kids are going to be able to continue to go to private school, whether or not you're going to be able to keep the condo, it's time to call Brava Law. We can walk you through this.